This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast. How are you? I hope you've all had a good week of recounts. Was your vote counted? Do you even know? Unfortunate what goes on here in Florida. Maybe one day they will actually fix it. Anyway, we're not going to talk about the election today. We're not going to talk about the recounts, unless somebody calls and asks a question. I want to start off by doing something that I think some people will actually enjoy. Hopefully you will. Lincoln Park Academy High School has a brand new speech and debate team. It had a team decades ago that, from what I hear, was at one time an outstanding, excellent, nationally competitive team. And nobody quite knows what happened to it. Well, we got it started again this year. And last Saturday, we went to our very first tournament. We had 2 competitors, and we had 5 people from the team come to observe, dip their toe in the water, see what it's like, and have already committed to participating in December at the next tournament, so that's now 7. And I know we have a few more that are going to do it, so we may actually have a team of 10 going next month. I want to congratulate those who went, those who participated, those who observed. I want to thank the administration at Lincoln Park Academy and the school district for actually permitting us to finally do this again after all this time. I've had the view for 3 years that Lincoln Park Academy, being a public high school that routinely is ranked in the top 10, 12% of the country, has to have a speech and debate team. When I was in high school, all the best high schools we competed against, they were great high schools. Bronx High School of Science, they had speech and debate teams. So finally, we do have one this year. We're competing now. We're underway. I've explained to the kids as I've volunteered to coach, and the other coach is a faculty member, happens to be my son's language arts teacher, and we certainly thank her for saying yes, because it's a lot of administrative time that goes into this. I waltz in a couple days a week after school, like today, and try to work with the kids, and she's dealing with paperwork. Who can drive? How long can we be gone? Where can we go? Do we have the permission slips? Are they notarized? It's amazing. It takes a lot. But what we found when we went to our tournament, we found teams in Palm Beach County and Broward County, 50 people, winning trophy after trophy after trophy. I mean, hundreds of trophies were awarded on Saturday. There were hundreds of kids participating in speech and debate. And the difference is in Palm Beach County and Broward County, they have a class, an elective called, guess what? Speech and debate. So those kids, every day of the week, have a class where they can work on their craft, hone their speeches and their debating, and over time, middle school, high school, they get really good. So it's one of our goals, hopefully next year or the year after, depending upon how long it takes to get something like that through the district, maybe to have a speech and debate class at Lincoln Park Academy. But we must crawl before we walk. We must walk before we run. And then we'll run away with the trophies.
Now, am I to remember this correctly? Did you not initiate the return of this?
I did, yes.
Well, congratulations.
Thank you. I'm proud of myself. I'm proud, really. Ms. Scherer is the language arts teacher who is the coach as a faculty member. I'm thankful to LPA's principal, Mr. Sanabria, for really supporting this effort. Really, it's tough if administration is saying, yeah, okay. It's a lot easier if they think it's a great idea. The idea of Lincoln Park having a speech and debate team, well, we're getting support and thinking it's a great idea. And that helps a lot to motivate people and to allow us to get places when we don't have the funding just yet. We don't have fundraisers, and where are we going to come up with the money? Some students can afford it, some students can't.
Right.
Well, it's nice when certain discretionary funds can be utilized because they think it's an important enough endeavor. Maybe if LPA had a football team, the money might go there, as with most schools. But I'll tell you something. I know from experience that schools, particularly very good schools, high schools that have speech and debate teams, forensics teams, it counts so much extra when a college admissions officer is looking at your packet. Because it's not just a sport. I mean, sports are important. They look at that too. But this is an academic exercise that you're volunteering for. It's essentially more work. And it's not just, you're not just learning basketball or baseball, where you do learn other things too. You learn team dynamics. You learn, working as a team, getting along with people. There are a lot of things you learn in those sports. But the thing that changed things for me, which is what I talk to the kids about, when I had a sophomore English teacher who told me, you think you're such a smart, you know what, go join the debate team. And I took up the challenge because I couldn't really say no, and it changed things. What happened was, as I started to debate, I realized I had to listen. I had to take notes. I had to write my cross-examination questions in the margins. And I had to pull evidence cards for my speech all at the same time. I wasn't even taking notes in class.
Yeah, well, you could be prepared when you start, but as you debate, your preparation
Things
has to change.
Yes.
Yeah.
So the process of learning to listen, take notes, write down cross-examination, and prepare your own speech, by pulling evidence cards that you need, all at the same time, I found all of a sudden, guess what? I'm taking notes in class now. I'm taking really good notes. I'm getting better grades on tests. And my school bag, which I don't think was a backpack in those days.
No, of course not.
I think it was this really stretchy thing, that went around the books.
Or we had lockers where we could dump our books and stuff.
Well, when I came home, I dumped mine on top of the washing machine. My mother's watching, right, Mom? You can call and confirm this if you want. And that next morning, the books were there on top of the washing machine for me to go back to school. Which
on
means
the way
I
out the door?
I didn't do homework. I didn't study. I got my C's and D's. And once I started doing speech and debate, C's and D's turned into B's and C's, and then A's and B's. And then by the time I got to college, A's. It takes time. So I think that, all these kids that are participating now, they're at a really great high school. They've got great opportunities and great advantages. And this is just another one that they can take advantage of and learn skills that will help everything else they're doing.
For the rest of their life.
And help for the rest of their life.
Yeah.
One of the things I told, the first meeting we had a group of kids show up, a lot of them, and, some you don't see again, but that's okay.
Well, they came to see what it was going to be about.
And one of the things I say is, this applies everywhere. If you want to go buy a car, do you know how to talk to another person, or are you intimidated? Are you the one that's going to be taken advantage of, or are you the one going to do the advantage taking by negotiating? When you need to ask your boss for a raise, are you too afraid to do it? Or if you even do it, do you do it timidly? Or do you go in with confidence, have your reasons prepared why you're going to ask for that raise, ask for it the appropriate way, pick the appropriate timing, not at the end of a bad day for the boss, and maximize your opportunity to get what you want. If you have to speak, in front of a board, or your company, are you going to be fearful and have panic and stage fright, which a lot of people have? Or are you going to be experienced enough now to get up, be confident, and show yourself off and maybe go up the promotion ladder? There are just so many areas. I mean, we all engage in public speaking every single day. If you're trying to return something and you don't have the receipt, sometimes it's the way you talk and the way you ask that gets you what you want. Sometimes.
Or I'm not leaving this counter until I get what I need.
you could use that too.
That's a last resort, though.
Yes. Or sometimes with me, it's, well, you'll be getting a letter on my lawyer letterhead, and that, once they get that letter, things often change. But it's, I'm speaking about it really much more than I planned. But the bottom line is, I'm thrilled we're here. I think that by the time these freshmen and sophomore, which is what we really have, 3 years from now, when the freshmen are seniors, and 2 years from now when the sophomores are seniors, I have a feeling this team will be much different. I have a feeling this team will regularly be competing and competitive in various events for trophies. I have a feeling this team will be taking home awards. And my goal would be that eventually, just like some of the teams that these kids discovered this past weekend that are powerhouses, that we walk in the door and they say, ugh, LPA is here. Mm-hmm. They're going to take 30 or 40 of these trophies. That's psychological warfare. Now, my kids this Saturday didn't know from that. But at the award ceremony, when they kept hearing Palm Beach Central, Suncoast, Dreyfus, they learned that certain schools win and win and win and win again. And so next time when some of these kids walk into their rounds, they may be a little intimidated, which I hope to work against. But it's a good thing if you can be the one doing the psychological intimidation. When somebody sees you walk in and figures, I'm not going to finish first in this round, the best I can hope for is second, then you're already a step ahead of the game. But that's going to take years, and it's going to take a lot of work. But we got our first mention in TC Palm, a nice article the other day with pictures. I'm proud of that. I know the kids are going to be overjoyed when I show it to them. I've made a little video of the photos that we took with some music that they'll see today.
So you're going to tell them you're in the newspaper. They're going to say,
Absolutely.
Newspaper, what's that?
Right, newspaper. Yeah. What's that? Well, the electronic newspaper, they'll understand that. I am looking forward to what they accomplish. I know my son is one of the two competitors that went last Saturday. And I didn't really get to see him the whole tournament because I'm judging other events. But it just by happenstance, when I came out of my first round, the event I was judging, I happened to see him in the courtyard of this massively giant high school that had like 10 buildings and using 6 of them for events, and you're walking all over the place. Just happened to run into my kid. And he had this big smile on his face. And I said, well, Aaron, so how'd you do? How was it? Did you have fun? And he's grinning ear to ear. That told me everything I needed to know. I don't care what place he came in the round. He competed. He went up against others. He felt good about it. He enjoyed it.
And he's learning the whole time.
Right, and he's learning. And the other young lady who competed, you could tell she felt the same way. It was fun. The observers, they all want to do it next time. So it had the desired effect. And that's a good thing. Anyway, enough about LPA. All right, so let's ask a question and see if I can get some answers at 340-1590. Okay? Just in case you forgot the phone number. Have any of you out there ever used a lawyer and replaced him or her for some reason midstream? If you have, I'd really like to hear from you. I'd like to hear why you made the decision to change lawyers, because I have a feeling I will hear a few different themes. They repeat themselves. Right now in my office this week, we got 2 new clients that on one I'm their second attorney, on one I'm the third attorney.
Wow.
Okay? One case is 5 years old, should have been resolved long ago. The other is 8 years old.
Wow.
Never should be 8 years old.
Don't you really just get sick of the whole process at some point and just...
You do, especially if the client's paying hourly and they're looking at those bills up and up and up and up and up. At some point you might have to say to them, is it worth it? Depends upon what you're fighting over. But the theme seemed to be attorneys who don't return calls. Okay, my attorney will never call me back. Attorneys who won't communicate with their clients, whether it's calls or letters or emails or faxes or carrier pigeon. I never hear from my lawyer. I don't know what's going on in my case.
And communication is a lot easier today.
Oh, you better believe it.
Because if you really don't have the time for the sit-down conversation, you can text them and say, hey, you know what? Here's where we're at. I'll try to get a hold of you as soon as I know something different.
That's right. And I tell my clients, not just the ones that are hiring me after they're replacing others, I tell all my clients, one thing I will promise you, you're never not going to be able to get in touch with me. Mm-hmm. It's one of the reasons I opened up my own solo practice. I was just tired of bureaucracy. And I tell my clients, whether you choose to call the office and go through Cheryl first, mm-hmm. the guard keeper, gatekeeper, or whether you choose to send me an email, really depends upon what you need to know. If you have a question about something that's going on or something I emailed you and it's going to be easy for me to answer in a few sentences, email me. Because if I'm sitting at my desk and I'm working on something else and I see that little envelope pop up in the lower right-hand corner, well, folks, I'm anal retentive when it comes to that. I've got to see what it is. If it's from you and it's simple, you might get an answer in 30 seconds. I don't know how you can do better than that.
Right.
If I need, if I'm really working on something else that is, my mind is in 4 or 5 different branches and I'm trying to keep them straight in my head because I'm working on a memorandum of law or something, I'll see what it is. I'll go back to what I'm doing, mm-hmm. and you may hear from me in an hour, 2 hours by the end of the day, okay? But you're going to hear from me. There are clients that laugh because they'll send me an email at 9 o'clock at night, and they'll get an answer at 3:30 in the morning. There are adversaries who hate that because to them it looks like I'm working at 3:30 in the mm-hmm. morning when really, you get older, you get up a little bit in the middle of the night, and sometimes you decide to check your email, and if it's something easy...
You might as well be doing something if you're not sleeping, right?
If it's something easy from a client, I'll respond, and if it's something that I can respond easily to an adversary, I do it on purpose just to show them that I'm working at all hours. I'm burning the midnight oil, even if I'm not. And it's psychological warfare, it really is, because I can't tell you how many adversaries have sort of looked at me and commented, what are you doing sending me an email at 2:30 in the morning?
You're making the rest of them look bad.
Well, no, they feel that there's, I don't know what they feel, but I can tell it bothers them. Clients, on the other hand, love it.
Well, because it feels as though you're working around the clock for me.
I don't think the clients think. I don't think the clients are stupid and they think I'm working 24 hours a day. I think they realize. But you did
check your email at 3 o'clock in the morning.
That's true. And that's true. And if it was simple, I chose to respond. Mm-hmm. And I do think that is appreciated when they wake up and all of a sudden they see at 6 o'clock in the morning or whatever.
They have an answer.
If they're lucky that they get up at 6, not like me.
Yeah.
And they see, oh, I have an email from my attorney. Mm-hmm. It's one of the things I like to believe that distinguishes my firm from a lot of other places. Not all, but a lot of other places. Another thing we always hear is that attorneys who don't involve themselves in allowing their clients to make choices. Now, there's a difference in strategy and tactics. Always gets confused. Strategy is an overall game plan. Tactics are how you implement the game plan. So, strategy,
that's me.
That just took it all out.
Yeah, it's okay.
Strategy, basically, if we have several options as to how are we going to approach either this lawsuit or defending this lawsuit, clients have to be involved in that. They're the ones that have the ultimate at risk. And if there are several possible ways to approach something, and they all have pros and cons, the client really deserves to be told, here are your options, here are the pros, here are the cons. What do you want to do? And if you still have questions about the different options, okay, well, that's what I'm there for. And then let's make a decision. Tell me which strategy you want to impose. I'll propose that strategy, and then for the most part, the tactics are up to me as a lawyer. Now, I may involve you in some issues of tactics. Do you want to take this deposition before this deposition? For the most part, that's really, I think, an attorney decision. Mm-hmm. But in some cases, there are reasons to ask the client whether they have a preference, and if so, why. And if it makes sense, do it the client's way. I mean, if you can, why not just do it the client's way? It's easier, they're happier, and they pay your bills more readily if it's an hourly case. Contingency, well, what can I tell you? But I hear that all the time. They don't return my calls, I don't hear from them, and I'm not involved in this case. And you're the one, if you're being sued, you're the one at risk. And if you're suing for something, my goodness.
No one can hear that but us.
Okay, because in my headphones, I just heard the TV game show that's on a monitor, and I'm wondering what is going on.
But now everybody
here.
knows.
I'm an honest lawyer. Everybody's going to know everything that goes on here. You screw up like that, I'm going to tell them all. So let's see what happens the rest of the show. Next thing I have is, why don't I have any input? Or I sent these draft interrogatory answers to my lawyer in handwriting, and that's what he sent out. Didn't look at them, didn't do what we all know President Trump's lawyers are doing in answering interrogatories to the special counsel, massaging the draft of President Trump so it doesn't get him in trouble. This is what lawyers do. So what's going on there? So if you're just sending something out that you get from your client, you're not really doing your job. You're cutting a lot of corners. So again, I would ask you folks, have any of you had any of those types of experiences? Have any of you had experiences or know of friends or family that have had experiences where you've had a problem with a lawyer? And because I'm curious as to what was the problem. Because they do seem to run in themes of about 5 or 6. Now, there are a number of client options when these things happen. In addition to, or maybe even before having to replace your lawyer. Sometimes these issues can be solved. Sometimes lawyers get busy and they don't realize what's going on, and if you let them know that, hey, I expect to be communicated with, I want to know what's going on, it'll be fixed. Sometimes it's not fixable. But I recommend, to somebody who comes into my office, who calls my office, unless they're absolutely determined and prepared, they're firing their lawyer, they're getting another lawyer, it's either me or somebody else. If the relationship can be fixed and they think their lawyer is a good lawyer, I would tell them, send a certified letter to your lawyer laying out what concerns you. Certified letters get lawyers' attention because lawyers know when you put something in writing, there's a record. And that could be a record that precedes a bar complaint. So lawyers do take those things seriously. Sometimes more seriously than a phone call, which you can never prove you made, and even if you can't prove what was said. So I always recommend a certified letter. Now,
And you can't record that conversation, folks.
No, not in Florida. Florida is a two-party state. I actually had somebody come in yesterday and tell me he had a recording of something, and there was an admission of serious wrongdoing, and I told him, you can't use it. You can't even acknowledge you have it. Don't speak to anybody about it.
What about everybody with their cell phones? I mean, if you're out in the open with it?
If you have no reasonable expectation of privacy, then it's not an issue.
Okay.
But if you're having a phone call with somebody, if you're having a conversation privately with somebody, and you have a reasonable expectation of privacy, then the Wiretap Communications Act applies. Mm-hmm. The federal law says only one party has to consent. Usually that's you. You're the taping party.
Yeah, you're right. You know you're doing it.
But it leaves to the states
the
power to require more protections. And Florida has adopted the two-party rule.
And it doesn't work by saying, oh, by the way, I recorded this conversation. I'm going to get you now.
No. What you I mean, we're on another topic, but it's a good topic. What you have to do is you have to be able to show that the person you recorded was aware that you were recording them, even if they don't verbally give their consent. You have to show they were aware. You know, if you say, I want you to know I'm recording this, and they don't say anything, you're not going to get in trouble.
Okay.
That's consent.
But that's before the conversation.
You're right.
Not after.
That is before, not
Yeah.
after. It is a felony in Florida, wiretapping. And that means you record a conversation on the phone or you secretly record your boss. You're actually committing a felony. And when you go to your lawyer, hopefully you do that before you tell anybody like the police that you have these tapes. The lawyer is most likely going to tell you, don't ever tell anybody else that you have this because you have inadvertently committed a felony and we're going to make believe the tapes don't exist and we'll do what we can to get the information in discovery. And sometimes that really upsets these people, but we are a two-party state, and that is just the way it is. But after that first certified letter, let's say it still doesn't work. Depending upon what the situation is, sometimes I recommend one more letter. The second letter has some very specific language to it. It basically says, solve this problem or I'm filing a bar complaint. And I'll tell you, any attorney who gets a letter that says bar complaint, is going to respond. And you may still end up just firing the attorney, but that attorney is at least going to respond. And if he doesn't, or she doesn't, oh boy, are you going to have fun when you file your bar complaint. Sometimes I do tell people, in addition to terminating their attorney, they should file a bar complaint. I mean, a case that's 8 years old and nothing happened for 3 years, because two different attorneys didn't do anything, that is not, I don't want to start saying certain things, but I'd say let the bar decide whether that violated some ethical rules of your duties to your clients and your duties of representation. Another thing you can do is, the attorney hasn't done very much, at least according to you, but you've had to pay them a heck of a lot of money. And so I usually say, what for? And they say, I don't know. Well, did you get statements from the attorneys, that you ended up paying? Yes. Did those statements, show like every day what they did and how much time they spent on it? Or was it like a one-sentence statement for the month of August, 31.3 hours, $20 million? Well, sometimes it's that latter, one-sentence thing, and doesn't cut it with the bar. Your records have to be detailed. And we all have, there are so many financial timekeeping programs out there. It's not hard to write Client A, drafted interrogatories, reviewed requests for production, reviewed documents produced by other side, telephone conference with client, email to client, 1.8 hours.
Made 6 copies.
Right. Well, that's hopefully your paralegal.
Like
You're not supposed to be billing them for that. But if you really think that you've been taken advantage of in terms of fees, Florida has what's called fee arbitration. If a client writes to the bar and demands fee arbitration, the attorney is obligated to participate. They don't have a choice. So the first step is it goes to a fee arbitration committee, which is composed of a lawyer, a layperson, and I'm not sure how they pick the third person, whether it's another lawyer or another layperson. I'm not really sure. I don't recall offhand, honestly. But it's not just all lawyers. And clients usually do very well in fee arbitration. And it's not complicated. You can go do it yourself. The fee arbitration committees want to see the lawyer's billings and hear about why they think they're entitled to that fee. And they're going to hear from you as to why you think that, no, they're not entitled to $10,000. I don't even think they're entitled to $5,000. And the committee is going to hear y'all. There goes the southern part from being here for 25 years. and look at the records, make a decision. Now, the lawyer is bound by that decision. The client is not. If you as the client are not happy with the decision of the fee arbitration committee, you can take it to court. But the lawyer has to accept it. So if you accept it, it's a done deal. You know, if the committee says you have to return $5,000 to the client and you're okay with that, it's over with, at least in terms of the fee issue. Now, ethics issues may not be over with because that's handled by a different aspect of the Florida bar. You know, that's a bar grievance issue. So, you know, in addition to discharging your lawyer and hiring a new lawyer, sometimes you have to look, was this just a situation where the two of you clashed? It wasn't a good fit between attorney and client. Okay, that happens. Hire another attorney and we move on. Or was this a situation where your attorney failed to engage in the minimally acceptable standards of professional conduct? And if that's the case, then not only do you discharge the lawyer, but you start looking at fee arbitration and you start looking at bar grievance. And I guess you all must have wonderful, wonderful lawyers out there. Because I'm not hearing from anybody saying, oh, my lawyer was horrible. That's fun to listen to. So again, it's 340-1590. Now, is the attorney always wrong? Oh, and somebody heard my plea. And Veronica bumps into the microphone. See, I'm narrating now.
Whoops.
And that's okay for a producer. All right. We have John on line one. Hello, John. How are you?
Hi, I'm doing well.
How can I help you?
Always a pleasure to listen to you.
Thank you. Thank you.
And I even enjoy Veronica, believe it or not.
Well, thank you.
Now you've hurt my feelings.
Someone does anyway.
How can I help you?
Well, you know, it's way past its limitations, but I wanted to tell you what happened to me and ask you if I had any repercussions. Back in 2000, I had emergency open heart surgery.
My goodness.
Well,
you're still here.
2000.
And you're still here. That's good.
Yeah. Only the good die young.
Yeah. So you must be pretty evil.
Well, I know I'm going where it's warm when I die, and all the bad girls are there, so it shouldn't be too bad. But what happened was I went to Martin Memorial with a lot of chest pain and, you know, all the symptoms.
Right.
And the cardiologist there did a catheter, saw the two arteries were blocked solid, so they shipped me down to Palm Beach, and the next morning I had the surgery. Well, I was in a lot of pain, and I was very careful about what I did because, you know, you can't drive for 6 weeks.
Right.
And all that. About 3 weeks later, I got terribly tired, could hardly walk across the room, and I kept calling the cardiologist that was kind of assigned to me through the hospital. It was a group in Stuart. And I called 4 days in a row, and they kept saying, oh, he'll call you this afternoon.
Right.
You know? And he never did. Well, I think it was the fourth day. I believe they put perhaps a nurse on the phone from the office. And she said, I want to level with you. I have to be honest with you. He's not calling you back, and he's not going to see you because you don't have insurance or money.
Okay.
If you come in with cash, you know, he'll see you. So I when she said to me, what's the problem? When I told her, she said, get into emergency right away. So I did. As a matter of fact, I went back to Martin Memorial. The same cardiologist did another heart catheter, swore out loud because the two arteries that they transplanted had collapsed.
Okay.
And by that time, I'd had a heart attack. And I wondered if I ever had any recourse.
You probably did, but as you say, in 2000, you had a 2-year time limit.
Oh no, I'm not talking now.
You probably did. I mean, it sounds as if there's at least some questions as to whether or not there was negligence.
Yeah.
And, the way Florida works, and I don't really do medical malpractice, I refer it out, but the way it works is generally the attorney has to have some doctors look at your situation. You get all the records. And you have to have 2 doctors who are willing to sign an affidavit that say that they believe that the other doctor or whoever it was, the anesthesiologist, whatever, failed to meet the standard of care. If you have 2 who are willing to sign on to that, then you're allowed to file a malpractice lawsuit.
Well, I wouldn't be suing the fact that the surgeon, did a poor job and he was negligent. I think I would be suing the cardiologist for not wanting to see me, but never told me.
Well, and see that's an aspect of just boorish behavior, but I don't think you probably would have been able to sue over that because unless you were able to show that, let's say, that failure to call you for 4 days for that reason causally led to an adverse medical event.
Right.
Whereas if he had called you right away and said, I'm not going to see you because you don't have money, and then you made a decision to find somebody else quickly or went to the ER, then you wouldn't have had this heart attack.
Sure.
Unless you can show causation, that failure to just return your call because you don't have insurance, it's boorish, but I don't think you would have had a cause of action for that.
Okay. I've been here 29 years. I came from Boston in '89, and I've had 2 surgeries in my lifetime, both right here in Florida. Now, the second one was I had gained probably at least 30 pounds more than I am now. And this was about 6-7 years ago.
Right.
So I opted for lap band surgery.
Yep. Mm-hmm.
And it was a surgeon from Jupiter. And I woke up and I was told that this surgery was aborted, I guess. It was.
Yeah, they didn't finish it once something
It,
happened.
it failed. What happened was when they were trying to snake the band around my stomach, they tore a hole in the stomach wall.
Okay.
And they stitched me up and sent me home.
Well, that sounds negligent.
Well, see, I never did anything about it,
Mm-hmm.
But what I wanted to tell you is, a week later, I had to go back and visit the doctor, and he said, "Let me tell you what happened, why it happened." He said, "There have been studies that obese men have a very thin stomach walls because they eat more carbs and not enough protein." And I said, "Well, if you know that, why don't you put an obese man on a high protein diet for 6 months?"
Before getting the weight surgery?
Yes. Exactly.
If the diet would have worked, you wouldn't need the weight surgery, right?
Well,
this is coming from somebody who checked into weight surgery, so trust me, I'm not criticizing.
What he's saying is the protein makes the stomach wall thicker.
Right.
But anyway, I said to him, "Well, if you knew that, why don't you put obese people on a high protein?" He says to me,
They probably won't stick to it.
Here's what he said. He said, "Well, the studies are inconclusive."
All right, well, what we're going to do, John, I appreciate your calling. I have another call, and then I'm going to tell my own little story about weight
All
loss.
right.
Okay?
Okay.
Thank you for calling.
Thank
Sarah,
you, Bubba.
Sarah on line 2, are you still there? Do we have Sarah on line 2?
Yes.
Hi, Sarah. How are you?
Yeah, fine. Now, I hired this attorney in late October, the very last of October, and he said, Thanksgiving's coming up, and he said then after Thanksgiving we have Christmas and New Year, so nothing's going to be done.
Okay.
So do y'all take that long of a vacation
Well,
that nothing can be?
Well, it all depends.
It
It all depends upon what you're asking to be done, what type of a matter it is. If it's a lawsuit that has to be drafted and filed, and in order to do that, the lawyer has to get documents and meet with you several times.
Well, I provided all that. I hired a drone to come do aerial photographs, and I gave him all that.
Okay.
And I had a general contractor come out who said that there was zero life on my roof left. So he has everything.
Okay.
Mm-hmm.
Well, okay. I would think that, if the lawyer has all the materials,
Mm-hmm.
getting the suit filed within 60 days should not be difficult. And the holidays really don't have that much to do with it. I mean, yes, You may be off 2 days for Thanksgiving, and you may be off maybe, who knows, a week for Christmas.
Maybe he had bigger plans.
Well, but
maybe he was going
okay.
out of town.
Maybe, or maybe he had a lot of other files that he was dealing with. In which case, he should have been frank with you about that. Whether or not you hired him at the end of October. Let's say we filed a lawsuit, early December. I'm going to tell you that nothing is going to happen until next year, because once that lawsuit is filed, it has to be served.
Well, it would be after the 15th of January because you have New Year's, he said, and then there's the Martin Luther King, so it would be
He's talking about all these holidays, huh?
Uh-huh.
Is there the chocolate holiday too?
Well, I guess there's no other major holiday after the 15th of
All right.
January until spring break.
I don't know who you hired. I don't want to know. It seems to me that if you're getting all those types of holiday excuses,
I get a feeling he's too busy to take your case.
I think Veronica may be right. And, obviously you met him, you spoke with him. If you feel you have a connection, then I would just try to talk it out.
He didn't tell me this at the first meeting.
Right.
He waited until the second meeting.
Is it an
that
hourly
he already
case or a
had my
contingency
check.
case?
Well, it was more than like 10 days later.
Okay.
But he'd already had the check to be hired, and that's when he told.
But he hasn't really done anything yet?
No.
All right. I don't know what his contract reads, but chances are very good that if you discharge him, you're entitled to that money back. And if he says it was a non-refundable retainer, I don't think the bar would look very kindly on that. The question is whether or not a 2-month delay is too much, and also whether or not, even if it isn't too much, whether you feel you're getting a runaround here, and if that's just going to be a signal as to what's going to happen throughout.
Mm-hmm.
If that's what you're feeling, then now is a really great time to change attorneys before the case is even started. Sometimes have a heart-to-heart. It may work.
Mm-hmm.
But, if you don't want to do that or, it doesn't work, then change attorneys now, get it over with.
I'd say if you have no confidence going in,
Well,
then
that's
it's
true.
probably going to stay that way.
I mean,
Oh no, I was fine on the first day. We had a long
Yeah.
chit chat, and then he told me his fees and everything. But see, he didn't tell me this until like 10 days later.
right. I mean,
He already had my check, and they were deposited.
I usually try to tell somebody who's becoming a client a rough time frame of when I'm going to do whatever it is I'm initially going to do. If they're hiring me, for example, to do a demand letter to threaten their employer or some air conditioning company or what have you, I'm going to look at, well, what do I need? What documents, what information do I need? Do I still need materials from them? How long is it going to take? And I'm going to tell them, I can probably get a draft to you by the end of this week, by the end of next week. Okay? If it's a lawsuit, and again, it all depends upon, do I have what I need? And then I look at my own case file and are there any urgent things that are coming up right now, or do I have time, to look at this case and devote the time to draft the complaint? And I'll give you an idea, okay, I can probably get this filed, within 30 days. Mm-hmm. But I would try, I would hope that most people would at least give you some idea up front as to what you can expect. But one of the points I'm going to make, in just a few moments, and it may apply here, although it may very well not apply since nothing's getting done, is that very often clients believe that things should occur at a lot faster pace than is realistic. For example, our circuit civil divisions tend to have one judge, if we're lucky, 2 judges, one for jury trials and one for non-jury trials. Well, the criminal division may have 10 judges, and family division may have 4 judges, and juvenile dependency may have 5 judges, and circuit civil is the stepchild. Why? Because all these other divisions have constitutional issues as to how fast they have to operate. Criminal division, they demand a speedy trial. You better be able to give a speedy trial. People have to be arraigned within a certain period of time. Mm-hmm. Circuit civil, it just doesn't matter. So they don't get the judges. Now, I have often run into situations where, let's say, I'm filing a motion to compel discovery. And it's a complicated motion. It's not one that's going to be done in 10 minutes. So I want to get an hour hearing. And my paralegal calls the judge's judicial assistant to find out when they have hour-long slots, and we're told 3 months from now. Not much we can do about that. We could continue working on the case, but not on anything that is relevant to the discovery we're trying to seek, because we can't get into court to argue the hearing. There have been cases where, you want a 4-hour or 3-hour block of time for something important. Well, I'll see you in 6 months, because that's the backload on circuit civil. Now, lawyers could try to finagle, put us on a list if somebody cancels, let us know. But sometimes that's just the reality of circuit civil. Now, hopefully, your lawyer is communicating with you as a client as to what is going on and why was this hearing set for 5 months from now. Instead of sending them, hopefully you're sending them a copy of the notice of hearing in the first place. But instead of just sending them a copy and waiting for them to call and say why, you're sending an email that says, okay, here's a copy of the notice of hearing. Want to let you know it's 5 months from now because, Judge such and such does not have any time to hear us for 2 hours before then. And then you as a client may be frustrated, understandably so. But if you're frustrated at your attorney, then unfortunately it's the client that's wrong because the attorney really can't do anything about it. And sometimes if the client doesn't realize that and talks to the attorney, then things get resolved because you have communication. But in your situation, I think that you're just starting and you're already running into so many holidays that are being mentioned. I think you might want to seriously consider whether you have the right attorney.
Well, when I went in, I told him I do not have computer, and I have a P.O. box, and I want a copy of every letter that send out.
And that's reasonable.
Copy, yes. And he said that he would provide that, but anything extra he would keep to a minimum to keep the costs down. And a phone call would be appreciated, or even a simple letter at my P.O. box. So far, I've not received anything, but it's still early yet. But 10 days later, when he told me that we're looking at Thanksgiving, and then there's Christmas, New Year's, and then we have Martin Luther King. He said nothing.
Okay, see that's where I start to work.
Did he mean that those days would be pulled out of the calendars because you won't get any business done?
No, it doesn't sound like it. It sounds like there's a reason as to why I can't be working on this. And if we're talking about Thanksgiving and Christmas, I could sort of understand. But once we start talking now about New Year's and Martin Luther King, now it starts to me sounding like excuses.
Back burner, like he's putting this case on the back burner.
Yes.
Okay.
Yeah. Well, okay.
All right.
Thank you.
You're very welcome.
You mentioned something about non-refundable retainer.
Yes.
Is there not a such thing, or is there a such thing?
There is a such thing as long as it's reasonable.
Okay, let's just say you give the attorney $4,000 as a retainer. You want to sue somebody, and then you go, you know what? I made a mistake. I can't sue this person. Circumstances are different. I'd like to drop it.
If it's then the attorney is most likely entitled merely to the reasonable value of his services.
Okay, not to just keep the whole thing.
Situations, I have fee agreements, some of them that say it's a non-refundable minimum fee. Okay, and it explains in the fee agreement the circumstances. If I say you're giving me $5,000 retainer, that's a non-refundable minimum fee, and I've put in $3,800 worth of work, and now you decide you just want to back out, I think I'm entitled to keep the $5,000. That doesn't mean if there's a complaint that I might not do something just to keep peace, and it's always better to have people saying nice things about you than bad things about you. But I think I'm entitled to that. It was clear in the contract. But if the fee you're going to get becomes what the Florida Bar would consider an unreasonable fee, you're not entitled to it. And so if the non-refundable minimum fee is $5,000 and the day after signing the contract, the client says, I don't think I'm going to be able to afford this whole thing, and so I don't even want to start it. Can I have my money back? You better give it back. You're not going to be allowed to keep it.
See, and then there was also a bill that showed what portion of that money was used
Right.
and what was left, and yeah.
And then it depends on how much are you talking about, and how long are you into it, and
Yeah, not long.
so-
It was. Are you crazy? You thinking you're
Guess
getting any
what?
money back?
fee arbitration.
Yeah, but how long do you have to do that? You'd have to do that fairly quickly.
I'm not sure what the time limit is on that, but it's easy enough. Go to floridabar.org, and it'll be pretty clear pretty quickly.
Yeah, pretty much just the word of what was said was accepted, and we moved on. So,
Right.
yeah,
So as we only have a few minutes left,
2 to be exact.
2 to be exact, we sort of finished up on the lawyers and have you ever replaced a lawyer, need to replace a lawyer. So let me tell you my little story, given what we were talking about with John. There was a time several years ago I considered getting lap band surgery as well. And I went to several surgeons and I listened to their presentations, and I ultimately went to talk to my own gastroenterologist who did surgery at Martin, and he knew me and knew me well. And when we sat down to talk about it, he says, "I'm not doing it on you." I said, "Well, why not?" He says, "Because you're not going to follow the diet, and you're going to have a bagel, and you're going to bust a lap band." You want to know something? He was right. So I wasn't really a good candidate. So I don't blame him for telling me I won't do the surgery on you. Probably saved me a lot of money out of pocket because it wasn't covered to have something that was going to fail anyway. But, these situations are different when you're talking to lawyers, when you're talking to doctors. And a lot of things can get misconstrued and misunderstood. And sometimes it helps to clear the air before you make major decisions. I'll give you one more example, and I know I only have very little time.
Well, we're going to go right from your show into our Christmas Kids broadcast.
Oh, right. That rabbi is a half hour later.
That's right. And we're going to the Christmas Kids out with the Mets.
So let's go Mets.
If you want to
go Mets.
If you want to wrap up your show.
Meet the Mets, step right up and greet the Mets. Bring your kiddies, bring your wife. Guaranteed to have a time of your life. These Mets are not really socking the ball.
Okay.
And they are not hitting home runs over the wall. All right, that's as far as I'll go. So I will wrap it up. Folks, thanks for listening. It's appreciated. We'll be back next Friday with Ask a Lawyer. We're going to go, instead of into Ask a Rabbi right away, we're going to go into a Christmas Kids show.
We are.
And in half an hour, you'll have Ask a Rabbi. So thanks for calling. My office number is 781-8003. And that's it for now. Thank you very much.
This
Bye-bye.
is WPSL Port St. Lucie.